You're listening to Talking Law, the podcast where business owners just like you discover how to avoid legal landmines and build value using smart legal tips.
Hi, it's Jelena here and welcome back to Talking Law, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. Now, we are back with the second and last half of this two-part series with Aspect Legal's very own Jelena Milanovic. In this last half, Jelena and I drill into what a force majeure clause is and what they should include. We talk about extension of time and delays in building and construction contracts. And finally, we touch on change of law clauses and how this can affect construction contracts. Now, don't miss out on all of this and more. So sit back, relax, and here we go with our discussion with Jelena. Okay, so we've talked about pricing. What I'd really like to talk about next is force majeure, because I think this is a really misunderstood concept. And actually, I feel like many people in the industry and far outside of the industry, perhaps don't even really understand what it means and how it's meant to apply. So can you talk about what the force majeure clauses, the relevance of force majeure clauses within the building and construction industry, and how do they usually appear in the contracts?
Yeah, sure. I mean, force majeure clauses were one of those things that were always in contracts, but no one really paid very much attention to them because, they talked about things like wars and things like that, as if that will ever happen, right? But then COVID-19 happened and suddenly everyone was scrambling through their contracts trying to see, do we have a force majeure clause and what does it say? So they've really come to the forefront and everyone's talking about them. But a force majeure clause really sets out a set of circumstances that are usually unforeseen circumstances or unexpected things that allow you to sort of pause your obligations under your contract for a period of time while that force majeure event is on foot. So sometimes they're really prescriptive and they set out exactly what a force majeure event is. And sometimes they're much broader. They just refer to, certain events and things that are generally not within, a party's reasonable control. So they can be worded any number of ways. And, certainly it's probably more beneficial to the party who's providing the building services under the contract for it to be as broad as it can be, rather than necessarily very, very prescriptive. But some of the things they should be capturing at the very least is, natural disasters, epidemics and pandemics, and their effects as well. Because what we've been seeing is that, COVID-19, for example, might have some immediate things that might prevent you from completing your project. But then, there's all these domino sort of effects that have carried on that you might want to try and stick under a force majeure clause if you can, like, these supply chain issues, labor shortages and things like that.
So, and I guess stepping back, perhaps if we explain to the listeners, because I find that this is, as you say, force majeure clause that had rarely had much focus until the last couple of years. And I found it fascinating because when we just had that moment in time in that March, April period where everything shut down a couple of years ago when COVID first hit, we got all of these calls suddenly, hold on, explain this force majeure clause to me, because this almost never seen clause before suddenly, sprang to prominence, and people wanted to know if they could enforce supply under their contracts, could they not enforce, were they going to be relieved of obligations in relation to time frame under the force majeure clause or not. So let's talk though about what it means. So we've got a force majeure clause that sits in a contract that says if we have an event that falls within the definition of force majeure, and that event happens, then you're relieved of having to provide that supply or services for a set period of time. And the force majeure clause will specify what that period of time is, what the obligations are for both of the parties afterwards. Sometimes they'll be very short. Sometimes they'll be, involved. And one of the things, and is there anything else that you want to add, Jelena, to that sort of discussion of force majeure as a whole in relation to the meaning of it and the application of it in the building and construction industry?
I suppose one of the things is, don't assume that, if something happens that there is a force majeure protection. It's really one of those sort of creatures of contract. So you have to have a force majeure clause in your contract to be able to rely on a force majeure event. And the other thing is, don't assume that if you do have a force majeure clause that it'll just, suddenly apply if there's a force majeure event. There's usually some sort of trigger that you have to make to try to have the force majeure clause apply. And it's usually, some sort of notice that you have to comply with within maybe a particular period of time that's specified under the contract. So they're probably the two things that people should be wary of as well.
And the other thing that I find is just the definition itself. Quite often I find people feel that force majeure must have its own absolute definition. And the reality is, as you said before, it's whatever the contract defines. So, I find that that's something that people don't really necessarily think about before. And when you're setting contracts up, the importance of you thinking through, well, what might be an event that I want to be defined as force majeure? What might be these events that are outside of my control that I might then say, I want to be ensure that if these things happened, I'm relieved of my obligation to supply for the period of time that I can't because of this event happening. And usually I find the approaches in contracts are cut and paste without actually thinking through, well, what is the practical application of what we've actually got in here?
Yeah, definitely. And, it has consequences, right? Because a lot of the time a force majeure clause will give an entitlement to terminate the contract if it goes on for long enough. So you really want to think about, what are those force majeure events that I want to include, and what are the consequences? Are the consequences just being able to sort of put a pause on the contract until the force majeure event sorts itself out? Or, will the parties, one or both, have a right to terminate at the end if it goes on for long enough?
Yeah. And I guess on the flip side of all of this, we're talking about how you should set up your contracts, from the beginning now to ensure that you're properly protected. But this also equally applies to contracts that might be on foot. It's important that, I guess, for you to understand, if someone is using a force majeure clause in a supply relationship with you, it might be that they're not necessarily interpreting the clause in the right way. So don't just accept, the notices under the clause if you haven't taken proper advice and aren't sure that you understand that, the way a force majeure clause is being enacted is actually in accordance with the contract.
Yeah, definitely. I mean, a lot of the time, builders, for example, or subcontractors are kind of like the meat and the sandwich, right? They've got this pressure, this upward pressure from their clients, but they're also relying on all of these supplies, and they're relying on all of these subcontractors to deliver their obligations under the contract. So I suppose another point that comes out of that is, firstly, if you are having someone that's trying to rely on a force majeure clause on you, to make sure that, you're looking at your contract upstream and seeing if you can sort of make similar sort of reliances there, because it might affect your obligations to your clients. But also when you're setting up new contracts, that you make sure that these clauses all sort of flow down and are back to back, so you're not in a situation where you're stuck because you've got, for example, a supplier that's trying to, rely on a force majeure clause, and you've got nothing to rely upon when you're, administering your contract with your client. Yeah. So, it's probably something that people might start looking at again now with the floods that are happening.
Yeah, absolutely. All right, so we've talked about pricing, we've talked about force majeure. Well, I think where I'd like to move to next is extension of time and delay, because that sort of fits in well with all of the areas that we've been talking about before. Where does this, where are the issues in contracts here, and what should we be thinking about including in contracts to deal with that issue?
Extension of time clauses are so important because in projects, time is everything. Time is of the essence, as they say. And a lot of the time, if you don't complete in time, you're gonna be potentially liable for liquidated damages, and they can ratchet up every single day that you're late. So making sure that you've got a clause in there that allows you to extend that end date for completion sufficiently is really important. So I think the key issue there is making sure that the events for which you can claim an extension of time are really broad enough to cover the risks to you and your project.
Brilliant. Yeah. Okay. So we need to ensure that the extension of time clauses are broad enough. What else do we need to be thinking about?
So one of the things that, catches people out a lot is some of the really strict compliance requirements in order to rely on an extension of time claim. So, you can set up the extension of time claim really nicely, and they can allow for all of these sorts of delays, and you think you're covered. But, in the everyday business of trying to administer a project and run a business, what we find is people usually can't comply with really strict notice provisions. So in a lot of these contracts, there is these multi-tiered notice provisions where you're having to provide a notice of the delay when it happens, and then every couple of days afterwards, providing all sorts of supporting material and providing it on a really regular basis. So when you're entering into your contract, really think about it. In my day-to-day practice, will I be able to comply with this clause? Will my project managers be able to, issue a notice within 24 hours of a delay occurring, or will I really kind of need a little bit more time than that? So that's really important. And then, if you are in a contract already, just being aware of what those provisions are and making sure that the rest of your team are aware of those, because a lot of the time the contract will say things like, if you don't comply with the notice provisions, then your entitlement to the extension of time is waived. So you don't have a right to an extension of time, even though in substance it's probably a really valid claim.
Brilliant. Now, have we covered off everything with extension of time and delay, or are there more things that we should be considering here?
The only other thing to probably keep in mind is delay costs. So if there's a delay, are you entitled to time, or are you also maybe entitled to costs? And that's just the way to think about risk and how risk should be apportioned for a delay. So for certain delays, will you be entitled to your overhead costs, for example, that are associated with continuing to run your business and keeping staff on while you're delayed? And that might be to do with particularly with delays that are caused by, the principal or the client, their breaches or their failure to get their act together and allow you to perform the contract. So, we found with COVID-19 and some of those sorts of delays, usually, principals aren't that willing to give you time and money. They're usually kind of just willing to give you time, but delay costs is maybe something to keep in mind for those sorts of delays that are really, the responsibility of the principal or your client that they can control.
Yeah, brilliant. So we've talked about pricing, we've talked about force majeure, we've talked about extension of time and delay. What else? Is there anything else that that we should be thinking about in terms of setting ourselves up for protection in these, difficult times?
The other one I would just briefly mention is change in law clauses. So they were another one of these clauses that are often just thrown into contracts that no one really paid much attention to until COVID-19. But what we're seeing is that legislation and governments can really affect your project and they can affect, your costs. So having an appropriately worded clause in there that allows you to claim costs if there is some unforeseen change in law, I think is one.
And so what do these clauses look like? Let's talk about what they usually say, what our listeners should be looking out for, and then what they should be thinking about in the application of the clauses. So what do they usually say?
They usually talk about, unforeseen things. So changes in law that couldn't have been reasonably anticipated at the time that you entered into the contract. And they usually talk about, that you being entitled to claim your reasonable costs that result from those changes in legislation.
Yeah.
So we had people, relying on those sorts of clauses as a result of some of the changes that occurred during the COVID lockdowns, for example, and people were trying to get creative and rely on them.
So what should our listeners then be doing, now that they're aware of that as a potential issue? What can they do in their contracts? What should they be looking out for and making sure is added in?
Yeah, so just making sure that, there is a change in law clause there, and one that allows you that's broad enough that allows you to claim back costs if there is some sort of change in legislation later on. Because, a lot of people say, well, COVID is kind of over, but it's not really. There could be a lot of other things that come into play. Now we're at this stage where we're deciding that we're living with COVID.
Fabulous. Okay, wonderful. Well, look, there's so many things there that I think are practical things that our listeners can take away in the building construction industry for how to protect themselves in what is an uncertain period right now that will not, I think, end up in great certainty in the very near future. This is a period of time that will go on for a while. And I guess it's about taking the learnings and making sure you're implementing them into your contracts, getting the right advice, if you're not sure how best to implement these into your contracts as a whole. And do you have any parting words for any of our listeners who are in the industry?
Yeah, definitely. I think too often people just sort of accept the contract that's been given to them on a sort of take it or leave it basis. But I think especially now, after the last couple of years, you shouldn't be afraid to read your contract and speak up if it doesn't reflect your risk appetite, and if it doesn't reflect what you really see as the deal that's been done between the parties. Because, everything's great while everything's going great, but if things do turn pear-shaped, then everyone will pull out the contract.
Yeah.
And we've seen that more in the last couple of years than we have ever before. So that's really the key thing. Don't be afraid to try and negotiate, because people are really expecting it now.
Yeah. And I think it's a really good point. And, every now and again, I have clients who will say to us, well, I don't want to litigate anyway. What does it matter? I'm not going to sue anyone under this clause. But that's not the point. The point is having strength in your contract so that you're in a power of negotiation if you're in a situation where you need to enact some of these clauses. And, some of the things you've talked about, Jelena, just really sensible anyway, in terms of reviewing whether we're using fixed price, what other ways can we look at doing this, and just even understanding some of those unusual clauses like force majeure, that we all feel a little bit more knowledgeable about now.
Yeah, unfortunately so, yes.
Yeah, that's right. Well, look, I just want to say a huge thank you for coming on to the show today, Jelena. And a huge call out, to you for your expertise in this subject, and to our listeners, if you would like some advice in relation to setting up these contracts for yourself, or understanding clauses that are in contracts that you're already committed to, or indeed dealing with issues that may have come up along the way, you can reach Jelena at Aspect Legal by booking yourself in a time to speak with our Legal Eagle team, and just mention that you're after our specialist advice in the building and construction industry. Jelena, I just want to say a huge thank you for coming on to the show today.
No worries. It was my pleasure.
Well, that's it for this episode, which was part 2 of our 2-part series with Jelena from our very own Aspect Legal, talking all about building and construction contracts. Now, I hope you enjoyed the second and last half of this podcast series, and make sure you catch more valuable topics around this area and around the legal tips and tricks for law generally in Talking Law. Now, if you're interested in talking to our lawyers about anything related to this topic, then head over either to our website at aspectlegal.com.au or to the show notes, where you can find a link straight to booking a free 15-minute discussion with our legal team. Well, that's it. Thanks again for listening in. This has been Joanna Oakey and Talking Law, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. See you next time.
Thanks for listening to Talking Law. Tune in next time for more smart legal tips and tricks to keep you clear of those legal landmines. If you want to get a download of today's show notes, head over to talkinglaw.com.au.
Are you looking for a top quality legal team to assist you in your organisation? Aspect Legal is an innovative commercial legal practice that specialises in providing fast and professional services for their clients. If you'd like to chat about how we might be able to assist you, simply head over to our website at aspectlegal.com.au to book in a time for a free discussion with one of our lawyers.